Hello guys, once again. I'm Dibya Prakash Lahiri, and today I'm back with another topic on law of contracts, and we will look at holder and holder in due course of time. So let's get started. So first of all, under section, we need to define what's a holder. Under section 8 of the Act, a person is a holder of a negotiable instrument who is entitled in his own name, A, to the possession of the instrument, B, to recover or receive its amount from the parties thereto. When the negotiable instrument is destroyed, its holder is the person so entitled to at the time of such loss or destruction. So we can, as we go again, it means that he is possession of that instrument, he is in possession of his instrument in his own name, or recover, receive from the parties that do. That means the party that it has recovered the item from. Now, moving on. What are the essential conditions of a holder? The person must be entitled to the possession of the instrument in his own name. Thus, if instrument is payable to the bearer, then he must be possessing it, or if it is payable to orders, then he must be endorsee. Second, if a person has actual possession of the instrument, but he has no right to possess the instrument, then he cannot be called the holder of the instrument. It's very clear from here. Now, what are the essential conditions of to be a holder? The third one, the person must be entitled to receive or recover the amount due thereon from the parties liable thereto. Any transfer of property that has taken place or the negotiation has taken place, so the amount that is liable for the party or the person who has taken the money or who has got the possession has to pay the money to the holder, and then the transfer takes place. Thus, it is not every person in possession of the instrument who is called a holder. To be a holder, the person must be named in the instrument as the payee or the endorsee, or he must be the bearer thereof. A person who has obtained possession of an instrument by theft or under forged endorsement is not a holder, as he is not entitled to, to recover the instrument. The holder implies de jure holder and not de facto holder. What is holder in due course? Under Section 9 of Negotiable Instrument Act, it defines as holder in due course as any person A who, for valuable consideration, becomes the possessor of the negotiable instrument payable to the bearer or to the endorsee or payee thereof, before the amount mentioned in the document becomes payable, and without having sufficient cause to believe that any defect existed in the title of the person from whom derives his title. Now, in important cases, firm KALKARAM CHARAN versus QUNWAR THAPAR in 1957, it happened to be one Baijanat Sayal sent demand draft rupees 4,000 to QUNWAR THAPAR. The said draft was issued by the Imperial Bank, Delhi, and payable at Imperial Bank, Kanpur. The draft came into wrong hand. An endorsement was made with false signatures and handed over to firm Kalka Prasad Ram Charan, who gave it for collection at Bharat Bank and not the Imperial Bank in Kanpur. Bharat Bank received the payment from Kanpur and gave it to the firm. Kuvarlal brought an action against Imperial Bank, Bharat Bank, and the firm. It was held that the forged endorsement did not convey the title to firm Kalka Prasad Ramcharan, and they could not be considered to be holder in due course. They had drawn benefits of this draft and were liable to make payment of the same to the true owner of the draft. That is, in the previous case, as we're speaking of, the liability of the Bharat Bank, who had collected the amount, could possibly be there, but the decree was not claimed against the bank. The Troy Bank, Imperial Bank, could not be made liable as it was protected under the NIA Act. Moving on, essential qualifications to be holder in due course. A. He must be a holder. B. He must have become holder for valuable consideration. Consideration must not be void or illegal, that is, a debt due on a wagering agreement. It may not be inadequate. The receiver of the NI, negotiable instrument, who gets the title to the instrument by the way of gift, cannot be a holder in due course. He can, however, be a holder. In the case of Waring versus GILOW, 1926, Lord Cave held that in case of endorsement, holder in due course does not involve the original payee of the check. It is because the holder includes the payee of the bill unless the context otherwise requires. Thus, it is difficult to see how the original owner of the check is the holder in due course. Now, what are the essential qualifications to be a holder in due course? A. He must be a holder before the date of maturity of the negotiable instrument. For example, a person who takes the bill or promissory note on the day on which it becomes payable cannot claim rights of a holder in due course because he takes it after it becomes payable. as the bill or note cannot be discharged at any time on that date. Second, a holder in due course must take the negotiable instrument complete and regular on the face of it. It is the duty of every person who takes the instrument to examine its form, because if it contains any material defect, he will not become a holder in due course. The holder must receive the negotiable instrument in good faith. Good faith implies that he should not have accepted the negotiable instrument after knowing about any defect in the title to the instrument, but notice of defect in the title received subsequent to the acquisition of the title will not affect the rights of the holder in due course. Moving on. In the RAPHAEL versus Bank of England in 1885, some banknotes issued by the Bank of England were stolen from B.S. & Co. in Liverpool in 1852. Notice regarding the robbery was given to the Bank of England and later circulated among all other banks by handbills in England and Paris. Such handbill was received by St. Paul, a money-charging firm in Paris in 1853. One of the stolen banknotes, £500, was presented to St. Paul on 25th June 1854, and after verifying that the holder had passport with due signatures, the payment was made in French money. However, St. Paul did not check the file containing the handbills about the robbery. RAPHAEL, who was St. Paul's correspondent in London, sought to recover the banknotes from the Bank of England. The Bank of England contended that St. Paul was negligent and did not look into the file informing of robbery, and he was not the holder in due course, and thus not entitled to payment. It was held that St. Paul was deemed to be acting in good faith. Forgetting to look at a notice does not signify the malafide, and thus the plaintiff was entitled to claim money from Bank of England. These are very interesting cases, guys. I would suggest you guys should go through it again and again, because there are certain facts which I have not mentioned because it was not necessary. But if you're really interested in getting to know for the judiciary and all the purposes, you can understand, the quality and increasing more your, substance to give your answers a better perspective and a better way to impress the judge or the checker. Now, essentials to be a holder in due course. Another one, besides good faith, the Indian law also requires reasonable care on part of the holder before he acquires title of the negotiable instrument. He should take the instrument without any negligence on his part. Reasonable care and due caution will be the proper test of his bona fides. It will not be enough to show that the holder acquired the instrument honestly if in fact he was negligent or careless. Now, what are the illustrations for a holder in due course? A bill made out by pasting together pieces of torn bill taken without inquiry will not make the holder a holder in due course. It was sufficient to show the intention to cancel the bill. The bill should not be taken without inquiry if suspicion has been aroused. Second, post-dated check is not irregular. It will not preclude a bona fide purchase instrument from claiming the rights of a holder in due course. It is to be noted that it is the notice of the defect in the title of his immediate transferor which deprives a person from claiming the right of a holder in due course. Notice of defect in the title of any prior party does not affect the title of the holder. Thank you so much, guys. And that's it. Have a great time. Have a good day.